Well, this is how the Democrats work. Donald Trump, in a Stalinist-like so-called trial, and Sam Alito, because his wife flew 2 flags, or maybe she flew one and he flew one, they're demanding that he recuse himself as they character assassinate him, as they have character assassinated Clarence Thomas, as they've character assassinated Neil Gorsuch. And the list goes on and on and on, because we're not dealing with a normal American political party. The Democrat Party hates America. And it will do whatever it has to do, including destroy our institutions, our traditions, our comity, C-O-M-I-T-Y, and, of course, the Constitution to get what it wants. Now, ladies and gentlemen, I don't know how to put this without sounding the wrong way. First of all, I want you to know President Trump will be on the program at 7 p.m. Eastern Time. He was supposed to be on the program last evening, but obviously the bloviating Stalinist prosecutor couldn't shut the hell up in front of the jury, so we moved it to today, which was always one of the options. So President Trump will be on the program at 7 p.m. Eastern Time. Come hell or high water, he'll be here. You know, I've spent, how old am I? Well, I've spent a long time, let me put it that way, 40 years, give or take, on constitutional issues, on constitutional litigation, debating it, studying it, analyzing it, diving as deep as the water allows me to go. And it is, in fact, very interesting, very informative to listen to the lawyers on TV. The defense lawyers, the former federal prosecutors, even some professors. But there's something missing. I watch, I say, there's something missing. And what's missing is the lack of the same kind of tenacity, the same kind of motivation to win these battles. I don't mean just to analyze them at a relatively surface level or to, what's the jury say? Well, I used to watch their eyes and their mouth and whether they got up and had to go to the restroom or... Got it. It's all very interesting to me. Very. But what do we do about all this? And they'll tell you they don't know. There'll be an appeal, they'll tell you. But it'll take time. And in the meantime, Donald Trump will be wearing a scarlet letter on his forehead. Exactly what the Democrats want, to take 2, 3, 4, 5% of the vote. A convicted felon, that's Biden. That's what his campaign says they're going to call Trump if this jury convicts him on one of 34 preposterous counts. The whole thing's a setup. The fix is in. And so you'll hear the lawyers go on about this, and they'll say the instructions are horrendous for a variety of reasons, and they're correct. They'll say that this is the greatest judge for the prosecution, even though I was a former prosecutor, I've ever seen. And they're correct. And they will say the judge's instructions to the jury not to infer Trump's guilt from Michael Cohen's pleas is correct, even though the judge throughout kept connecting the two. Great point. I agree 100%. And for 1,000 other reasons. This case has been one manipulation after another. To what end? To interfere with this election. To get a conviction on anything. Anything. Maybe it's a tax issue. Maybe it's an invoice. Anything. Just one. Just one. because by the time the appellate process in New York, Democrat judges and so forth and so on hear the case, maybe they'll even rule for Trump, it's too late. And they now have no answer to this. What do we do? What do we do? I posted something that my friend Arthur Ferguson, fantastic lawyer, had said not that long ago. And I posted it, and then I've added to it effectively. And I see our friend Brett Baer is using it on TV. Good for him. Somebody, finally. In Bush versus Gore, the United States Supreme Court interceded in the Florida Supreme Court's deliberations because that court was changing the Florida voting system on the fly, thereby violating the equal protection rights of Florida voters. The state court was establishing new standards for resolving a presidential election. The Manhattan trial court has done worse. In the farcical hush money case, it has taken up a case in which there is exclusive federal jurisdiction involving the federal election campaign, despite the fact that the federal agencies with authority over enforcing federal campaign laws, that is the Federal Election Commission and the U.S. Attorney's Office in the Southern District of New York, declined to bring charges. Judge Juan Merchan is conflicted. His daughter, Lauren, is raising tens of millions of dollars on behalf of her Democratic Party clients. Collateral evidence has been abundant and has no probative value. The opposite. The elements of the supposed federal offense were never articulated by the state or the court. The imposition of a gag order on the defendant, who's the future Republican nominee for president during a national campaign, raises all manner of First Amendment questions, problems, and concerns. Moreover, this state court could easily have avoided influencing and interfering with the federal presidential election. This is from the Blaze that published it. Merely by setting a later time for the case if the court actually believed it somehow had merit. After all, the state waited years to bring it. Therefore, there's not only a federal constitutional equal protection violation in that this state trial court has purposefully interposed itself into the federal presidential election without authority or jurisdiction, but the court has also violated the federal constitutionally protected due process rights of the future Republican nominee for president. And the voters are to determine the federal election outcome without the interference of a state court attempting to influence the result. If President Trump is found guilty of any of the 34 charges, I would strongly encourage his attorneys to seek an emergency appeal to the U.S. Supreme Court based, at least in significant part, on Bush versus Gore. Now, I've added online the following. In Bush versus Gore, 5 justices agree that there was an Equal Protection Clause violation in using differing standards of determining a valid vote in different counties, causing an, quote, unequal evaluation of ballots in various respects. As I said earlier, here it is actually worse. To crystallize even further, here we have a state court acting without jurisdiction, influencing a federal presidential election by, among other things, preventing the putative GOP nominee from campaigning, meaning hundreds of thousands of voters at rallies, draining resources from the campaign to legal expenses, etc. That is, handicapping Trump and the GOP, thereby causing, quote, an unequal, unquote, federal election playing field. And in doing so, the state court has eviscerated the candidates' due process rights in a host of ways. No need to list them here. There's a very famous attorney who doesn't accept this. And I posted this. An attorney who argues against my prior post regarding Bush versus Gore essentially asserts that the jury might convict based on tax law or false invoices, but not a constitutional issue. Further, he argues that if the judge stays sentencing during appeal, there would be no reason for the court to take up the case. I find this all the time, that these guys totally miss the point. And I write, unfortunately, this misses the point entirely. This would not be an appeal based on the jury's choice for conviction. It would be based on the actions and process used by the state court and the prosecutor, that is the state of New York, to get a conviction. That is to interfere with a free and fair election. That is the purpose of all the manipulation and absurd rulings from the state court on behalf of the prosecution. Now, you've heard them say this for weeks, but they don't put two and two together. The state appellate process has nothing to do with this as a federal constitutional matter. In fact, it would just further delay an ultimate resolution up the state chain. And I'm saying that process is the problem. And, of course, the urgency of the High Court, the Supreme Court of the United States, taking up the case quickly seems obvious. That is, every day that passes, this unconstitutional state interference has an impact on the federal election. Now, it is impossible to predict what the High Court would do, including whether it would take on this case. But that's always the situation. I'm simply paving a possible road to the Supreme Court if that is a preferred route, and I think it is. So to put even a finer point on it, the rebuttal is, well, what if they convict on a state tax issue? Or what if they convict on the state financial issue, reporting issue? Well, first of all, that reporting issue would be dead altogether, as they keep saying on TV correctly. It had a 2-year statute of limitations, so you needed at least an inference of some kind of federal law, federal election law in this case, they argue, with great ambiguity. But that misses the point, too. I said Bush versus Gore, where they changed the voting system in county after county after county, and the Supreme Court of the state kept changing the voting system for the state over and over and over again. And finally, the United States Supreme Court steps in, stops the Florida Supreme Court, and says what? It doesn't say what I argued, even though Scalia and Thomas and I agreed, which was this is a violation of the election process where the state legislature has authority and the state Supreme Court is rewriting the law. As the Chief Justice, then, of the Florida State Supreme Court indicated, in order to get a majority, they wound up with a 7-2 vote. The majority, the other 5, joined by Scalia and Thomas, they said, no, what we have here is an equal protection problem. I said, not really. Oh, yes, we do. Voters don't know in which district. They have different standards for allowing their votes to count. Therefore, it violates the Equal Protection Clause. Well, ladies and gentlemen, obviously the facts are different in the Trump case, but it does involve the Equal Protection Clause for the reasons I said. The putative Republican nominee, that is, the man who will be the Republican nominee for president, the Republican Party, Republican donors, Republican members of the Republican Party, and Republican voters are being handicapped. It's not a level playing field. The playing field is unequal, quote unquote. Because a state court and a state prosecutor are interfering with the election process. It has nothing to do with the specifics of the conviction. It has everything to do with the fact of a conviction based on the manipulation by the state. Now, does the guy understand what I'm saying? You know what I'm saying, right, Mr. Badus here?